Well, first of all, good morning, Your Honors. Sean Dingus on behalf of Appellant Stephen Greer. I'll just start with what I think is the clearest error I believe that the trial court made, and that is with respect to assignment of error number 2, where the trial court found that my client or clients had not asserted sufficient operative facts to give fair notice of the breach of contract action. And I believe if you look at the amended complaint, and it's a fairly long complaint. I've been a trial lawyer for 21 years, and I've never in my entire life written a complaint this long. I usually write about a tenth this long, so there are probably too many facts in the complaint for my liking if I was to prosecute the case. But for this purpose, I think it serves its purpose of putting Lycan on notice, sufficient notice at least, to that there's a breach of contract. And you can look at the specific facts in the complaint. He alleges that he asked on behalf of his company and himself as well to look for signs of prior damage to the car. He agreed to pay Lycan to inspect the car for damage from a previous accident. It's important to point out at this point in time as well that while my client is a medical doctor and he's qualified to diagnose medical conditions, he's not qualified to diagnose mechanical problems with cars or conditions with cars. He had some concern that there was a symptom, just as much as you would have a symptom of a fever or blotchy skin going for a medical condition. He saw a wobbly wheel and thought, well, you know, that's potentially a symptom of something worse, that's an underlying cause. So he wanted Lycan and App.No to research, investigate that underlying cause. He's not qualified or an expert in that field. He's relying on other experts' analysis, investigation, and opinion to know whether there's any damage to that car. That's number one. There were some arguments in the briefs, in the appellee's brief, that, well, he knew it was damaged. No, he didn't. He had some suspicions and concerns it was damaged, but he's not an expert. He relied on others.
You don't dispute, though, that the contract that was held for the car was as is?
It's absolutely, it's as is. I don't dispute that, but it doesn't excuse App.No and App.No with respect to contract of making misrepresentations about its condition. If there are misrepresentations about the condition itself, then I think that does go to fraud. I think he stated a claim for fraud. I think he stated a claim for negligent misrepresentation, which was never really brought to the trial court's attention or more importantly, to my client's, but my client's put on notice of the negligent misrepresentation count that was part of the MSJ, at least the trial court found to be part of the motion for summary judgment. He was not put on notice, and therefore he did not address negligent misrepresentation in his memo in opposition. So he wasn't given a fair chance or fair notice to do that. And that goes to, I believe, assignment of error number 3. But many of these counts were dismissed on the pleadings. So you just have to look at the pleadings. We have to assume that everything in the complaint is true. Everything in the complaint is true. If you consider everything in the complaint is true with respect to the pleadings, he has stated more than sufficient facts to survive dismissal. As far as summary judgment is concerned, there are a couple issues there. One is that his attorney, he relied on his attorney's advice. I did not represent him. His attorney actually filed a motion to strike the motion for summary judgment under an erroneous belief that that somehow told his time to file a memo of opposition, which he tells my client about. So he relies on that. The attorney was not granted leave to withdraw until well after that deadline passed. So I think it's reasonable for the court to have allowed him to fully brief that issue so we can have a decision on the facts, on the substance, rather than on procedure. I don't think it would hurt anything to allow him a chance to do that. The trial court can still grant the summary judgment, but at least give him an opportunity to do that because he did rely reasonably on the advice of his attorney. I mean, he was going to assume that his attorney is accurate.
So I think what you said in your brief, I want to make sure,
Sure.
because I was maybe a little confused with what you were saying here, that the attorney had filed
He had filed a motion to withdraw, but he was not withdrawn.
No, I understand
Yeah.
that.
Yeah.
But he had filed a motion to withdraw before the memorandum.
He'd actually filed the motion to strike, and then I think the motion to withdraw, and then the motion to withdraw was granted, I believe, 2 weeks, 15, 16 days after the deadline passed.
For the memorandum.
For the memorandum of opposition, yes.
All right.
Thank you, Your Honors.
May it please the court, my name is Rick DeLisi, and I have the pleasure of representing Finest Auto Wholesale today. I will take 7.5 minutes, and per agreement with my co-counsel, or with counsel for Lycan, and if there's any remaining time that I do not use, I'll be happy to donate that to Lycan. I'll start right where Helen started. The complaint in this case is very long. The plaintiff in this case has doomed himself by all the admissions set forth in that very long 126 paragraph complaint, then 141 paragraph amended complaint, and the plaintiff was deposed over 3 separate days. So we have 3 parts of his deposition. If you look at all those admissions in there, his case is wiped out as a matter of law and on the pleadings as to the Ohio Consumer Sales Practices Act claim. For those reasons, we ask the court to affirm all of the orders made by the trial court. So only assignments 1, 4, and 5 pertain to my client. The first one is obviously the fact that the company that bought the car was a company. It was not an individual. In support of our position, we have an Ohio Supreme Court case directly on point. Plaintiff relies only upon a dicta from a decision called Hamilton versus Ball out of the 4th District, in which the court allowed a husband and wife, extended the right of from one person to another person through the union of husband and wife to allow somebody else who was not a party to the contract to assert a claim. That's not what we have here. We have a company on the contract, and plaintiff is trying to use that opinion, that dicta and that opinion, to extend it from a company to an individual as opposed to individual to individual. It's in no way related to this case. Again,
So
we have,
the company was on the actual title?
it was, the company was on the title of the car that bought this car. And that was right in their amended, right in their complaint and amended complaint.
So did the attorney represent Cortex, or did the attorney represent Dr. Greer?
Well, in the complaint, it was Cortex DBA, Dr. Greer. Then in the amended complaint, he separated them as the 2 separate people. So I think that, because they did that to get around the motion for judgment on the pleadings.
I
And,
can't remember, was there a loan?
no, he paid $19,000.
Do you know where that money came from?
It was on a Cortex check. Then he revoked the deal. He unilaterally rescinded. Then he sent another check, which was also a Cortex check.
I remember that.
Okay, and my point is, you can't have it both ways. If you want to avail yourself of the protections of being an LLC, you can't pick and choose and say, then I want the protections of being an individual. You can't have it both ways. So, for example, and I don't know, but what if Dr. Greer was in a car accident right after this? And it was a catastrophic injury on the other side. He'd say, well, hey, that wasn't me, it was my LLC. You can't get my personal assets. So he's kind of trying to pick and choose. So he elected to avail himself of those protections of buying this car as an LLC. He can't now change because it suits his purpose to seek attorney's fees through the Ohio Consumer Sales Practices Act. So I think that position is pretty solid, and the judge was right in doing that. Then summary judgment's granted. After that, after all the discovery, and plaintiff files a motion for relief from judgment saying, hey, I didn't know, my attorney said it was okay. It's my position that that issue is not preserved on the record. He never filed an affidavit or any testimony or anything from his lawyer saying, hey, I misrepresented, or I gave poor advice to my client, I thought he was protected by this. There isn't anything in the record. And more so, there's no proffer of any evidence. He never filed a brief in opposition. This is what I would have done had I had the opportunity. So I don't think it's in the record, and I think we can dispose of that issue on that basis. But if we want to get to beyond that, the plaintiff still has the burden of showing that he has a meritorious defense or claim to present if relief is granted. It's not automatic. You can't just say, oh, my lawyer told me I was protected. It's not automatic. He has to meet some kind of burden. He hasn't done that. And so I've taken somewhat of a harmless error approach in my brief. I've said the plaintiff cannot create an issue of fact, has not and cannot. The contract issue, the breach of contract, it's replete with as is. Plaintiff's counsel admitted that, or appellant's counsel. And he can't establish fraud as a matter of law because the deal was dead. He walked away from it, issued a stop payment, and his testimony is very strong in that. He said the purchase would be off. That's on page 151 of his deposition, which is attached to document number 163. He also stated, and this is a quote, because of all these red flags, I did indeed cancel the purchase. And then there's no knowledge. You know, my client buys cars at auction and sells and resells them for a small profit. The Carfax indicated there was no evidence of an accident, so.
That's in the record somewhere.
Yes, it is, yes. He can't establish reliance because he completely ended the deal. He can't establish knowledge of falsity. So as a matter of law, he cannot establish the elements of those claims. We do not need, the court did not commit an error by denying the motion for relief from judgment. The fifth assignment of error is that simply because Judge Wells, who, by the way, was very patient, gave the plaintiff tremendous number of opportunities, generous amounts of time, simply because he recused himself, the orders that he issued are not rendered void, they are voidable. So then Judge Gibson was not compelled to eliminate all of those orders just because Judge Wells recused himself. Plus, it was the plaintiff who asked for the recusal. So Judge Wells, you know, being above board and avoiding all appearances of impropriety, recused himself, and then the plaintiff saying, okay, now I get to start from scratch. So I think that is an easy assignment of error that should be dismissed and disregarded. I thank you for your time. I'll yield whatever remaining I have to Mr. Long. Thank you.
Thank you, Mr. DeLacy.
You have exactly 7.5 minutes too.
Please, the court, ladies of the court, panel members, it's important to the appellee Lycan here that the court recognizes that there are 3 separate transactions involving the Cortex 2012 Mercedes vehicle. Number 1, there's a transaction for the purchase of the vehicle. There was a commitment made by the appellant Greer on eBay. He came and picked up the vehicle, and eventually Cortex paid and was titled the vehicle. The second transaction was between Lycan and Finest for the inspection of the vehicle. Mr. Yolnowski made the appointment with Lycan, brought the vehicle to the Lycan, negotiated the terms of the inspection, and was invoiced for the inspection, although there was no charge. Lycan completed the used car inspection. And then there was a third transaction which involved Lycan and the appellants in this case. Based upon the inspection, Lycan had recommendations for service for the vehicle. They contacted Greer, which was the first contact they had. They explained the recommendations, gave Mr. Greer an estimate. Mr. Greer accepted those recommendations, Lycan completed the work to Greer's satisfaction. He came and he picked up the car. Now this third transaction is the only one that involved the appellants in Lycan. And there's no issues in this case relative to that transaction. The appellant has not made any complaints, has not brought up any issues, whether a breach of contract, misrepresentation, or a Consumer Sales Practice Act issue on that third transaction. So we get to the first 2 transactions. First, the breach of contract claim. appellants have a burden, brevity of contract, meeting of the minds and terms, valid consideration, damages. On the face of the complaint, it doesn't exist. There's no evidence in the face of their complaint that there's a contract between Lycan, strike that. There's no, based upon the face of their complaint, the first two transactions didn't involve Lycan and the appellants. Again, the first one was between Mr. Ulanowski and Finest Auto and Mr. Greer and Cortex, the appellants, and the second one was between Lycan and Finest Auto. So how could there be a contract when Lycan's not a party to either one of those transactions? And it's clear from the face of the complaint that that's what alleged.
Well, and there's no allegation of third-party beneficiary or anything?
Well, there's been no argument of a third-party beneficiary on it, and I don't think it meets those requirements as well.
Because the contract, no matter who was entered in, between which parties it was entered into, obviously was for the benefit of Mr. Greer.
Your Honor, all that was asked for was a used car inspection. That was completely with satisfaction by Lycan. I don't think.
And how are you getting that? Is that in deposition testimony?
No, Your Honor, that's based on the pleadings. I mean, it's alleged in my answer, and there's no complaints. Although he alleges a misrepresentation made, he doesn't allege what the facts of the misrepresentation were. All he has is a bald allegation, which is in a transaction which Lycan wasn't even involved in.
So what was the bald allegation? Obviously, we'll go through the blank.
The bald allegation is that there was a representation the car wasn't made in an accident.
The car wasn't what?
Was in a prior accident.
That it was not.
Yeah, it was alleged in his complaint, it's there. But, you know, that would be an issue that would be between the other parties, not between Lycan. Lycan was involved with the transaction for the purchase, and Lycan wasn't involved with the transaction. Strike that. The appellants were involved with the transaction for the inspection. There's no communication between Lycan and Greer until after the inspection had been done. It was verified later, and that comes into the summary judgment argument as it relates to the misrepresentation and fraud claims, as all the conversations were documented by email. And in the end, Mr. Greer even admitted in deposition testimony, in the summary judgment argument was cited as it was in my brief, that Greer admitted he didn't bring up any indication of a prior accident or concern until after Lycan he had picked up the car and delivered it from Lycan, after all the repairs had been done.
Well, there's no duty to raise that, is there?
I'm sorry?
There's no duty to raise that.
Well, Your Honor, if he's claiming that we misrepresented that the car was in an accident, he's got to bring it up and let us know about it.
Well, if you're doing an inspection, so that's, wait till I finish my question.
Okay.
If you ask somebody to inspect a vehicle, okay, isn't that something you would assume that they would tell you, that if the car's been in an accident?
Well, Your Honor, okay, it was a used car inspection. It's an inspection that has a list of points that's covered on a form. It doesn't include opening the trunk or looking at the body or looking at the framing. It's a mechanical inspection. There was a concern about a wobbly right wheel that was looked at, that was brought to the attention, but nobody told Lycan to look at it as it relates to a prior accident, and it wasn't. I mean, if they were asked, they would have. A Carfax was run on the car, it didn't show any prior accident. Lycan is, this going into the deposition testimony, had checked with Mercedes-Benz, who keeps records on these vehicles as well. There was no indication that it had been in a prior accident. But Mr. Greer can later claim that Lycan misrepresented the fact that it was in an accident, committed fraud and misrepresentation when he didn't even tell him that he was concerned about it until after the car had been serviced. How could there be a representation from Lycan? I don't know how it can be inferred from a used car inspection, Your Honor. It's not included within the used car inspection's scope.
The check sheet is one of the pieces of evidence that are in the trial.
Yeah, I'm sorry, the what?
The check sheet, that mechanical.
It was an exhibit at the deposition. I don't know if it made it up to the
It was
appellate
an
court or
exhibit
not.
at the deposition.
Yes.
Well,
It's a mechanical inspection.
I'm sorry, but along those lines, Lycan was, some of the claims, I'm not sure, I can't remember, I have to go back and look at everything, but some of the claims were on motion for judgment on pleadings, or
That's correct, the breach of contract claim and the consumer sales practice claim.
So that wouldn't have been available to be introduced for that?
That's, as I indicated before I started, we're getting into the depositions at the point when I talked about when Mr. Greer testified that he never brought up the prior accident concerns until after the vehicle had been serviced by Lycan. You are correct with that. But, Your Honor, there's no allegation in any of the pleadings that there's terms in the contract with Lycan, that there's an existence of a contract with Lycan, there's no privity alleged in the complaint as to a contract with Lycan, and there's no written agreement, if there had been a written agreement attached pursuant to 10D to the complaint. On the Consumer Sales Practices Act claim, which was also a ruling on judgment on the pleadings, Your Honor, we had...
Counsel, you're actually out of time. I'm sorry. Thank you. We have 5 minutes for you.
Thank you, Your Honors. The fact is that Lycan would never have been involved in this case had my client not wanted to find out if there was some root cause to the tire wobbling. Again, I go back to the fact he's not an expert in that. He wants to know, is there what's the root cause of that? Is there a more significant problem than just the wheel wobbling? Is it the wheel itself? Is it something mechanical? Is it something from prior damage? And in the complaint, he specifically alleges that Lycan, its representative, represented to him that had not been involved in a prior accident. This was not after the tune-up and some new tires were put on. This was before. Now, the fact is, he is relying on Lycan's representation to complete the purchase of the vehicle. Without that representation, he doesn't purchase the vehicle. And almost as alleged in the complaint, also in the deposition testimony, he later finds out, when he takes it to another car dealer in Columbus, immediately they diagnose that it's been involved in another accident. So clearly, he relied on the representation of the Lycan representative to complete the transaction with Finest Auto, and then the transaction, there's a transaction between Greer and Cortex and Lycan. That is, find out what's wrong, what's causing this wheel to wobble, is there prior damage, and they represent it's not. So he relied on the representation to complete the transaction.
Isn't it possible that it could have been something other than an accident that made the wheel wobble?
Absolutely, and that's what he wanted to find out. Absolutely could have been. Again, he's not an expert in that. Just like medical doctors, when they're diagnosing a patient, they're ruling out other causes, right? Differential diagnosis. Same thing happens with car. Ruling out what else could have caused that wheel wobble. And of course, one of those is a prior accident.
Well, the main thing is that what is actually in the complaint.
It's in the complaint, yes.
It's in the complaint that, just what you said, I mean, we'll go through.
Yes,
the complaint.
I'm fairly certain it is. It's a very long complaint. There was a lot of deposition testimony, so I apologize. It's not intentional if I mistake something that's in the deposition versus the complaint, but I'm fairly certain it's in the complaint. I know it's in the evidence at some point in time. With respect to the CSPA, again, with respect to my argument, I think the trial court gave the interpretation of the Supreme Court's holding too narrow of an interpretation. The Supreme Court has said an individual need only be engaged in the consumer transaction, not complete it or be the only party to it. Steve Greer is clearly an individual, clearly a natural person. He was clearly engaged in the individual transaction and in the consumer transaction, I should say. He signed his name. The complaint alleges that, and the deposition testimony clearly establishes that he was involved in that.
But if that's the case, I mean, company, even though it's regarded as a person, doesn't necessarily, it's not gonna have somebody, it's not gonna be able to order without a person being involved. In other words, there always has to be a person acting.
There
So
would
if
be.
So if you take your position, then it would be, anytime an individual is involved, then it wouldn't be consumer anymore, would it?
Well, typically if it's a company, then you're going to have multiple people involved in the decision-making process. Here we have one person. And he's testified, and I believe included in the complaint, that the purpose was for personal use. It wouldn't be for personal use, it would have been purchased by a business, so I think you have to consider the facts and circumstances
Well,
involved
that's
in his purchase.
inconsistent though, isn't it?
What's that?
That's inconsistent though, isn't it?
Inconsistent in what way?
Well, if he says it's for personal use and he puts it in the name of his business.
I agree, but that's what he alleged. That's what he testified to, and that's what he alleged. With respect to preserving the record on the motion to vacate, I believe he preserved that in filing the motion. I think the motion for relief from judgment preserved that for the record. I'm not sure what else he would need
I was a
to
little
do.
confused over that, and I
Yeah.
didn't want to take up so much time on the other side because he had two people, but this was regarded as 60B.
Right.
Wasn't the case still pending?
No, but all the motions had been decided at that point in time.
Okay,
Because
everything had been ruled on, so it was a final
Everything had been,
order.
yeah, there were 4 orders,
Okay.
and it's hard to keep track of them, but there were 4 orders. And the trial court found that it was Greer's trial attorney's he intentionally and strategically didn't file a memo of opposition, which makes no sense, because why else would he have requested 2 weeks after the ruling on the motion of strike to file a memo in opposition?
And you're out of time.
Thank you.
Thank you. Thank you both.
Thank you.
Both sides, I should say, and all of you for your presentations to the court. The court will take the matter under advisement. We will issue a written opinion, which will be sent to both sides, all sides, I should say, I keep saying both, all sides. And also we release on our website here at the Ninth District Court of Appeals. So thank you very much.
Thank you, Your Honor.